And we're glad to have with us this morning Attorney Cordy Morgan to teach another of his Citizens Law School classes. Before we get to the first break and you get into that, Kanye West may need a good attorney. Would you be willing to, if he calls you, would you represent Kanye
Well,
West?
I would have to say there's probably not enough money in the U.S. Treasury for me to represent him.
All right.
So, just so you know.
Oh, I just wanted to make sure. I got that written down. We'll take a commercial break and come back and turn it over to him. Now, this is one of those shows. He won't take calls today. If something stimulates your mind, and he will take calls the next time he's on for his regular day. But this is his class, the Citizens Law School class. No calls today, please. And we'll be back with Attorney Cordy Morgan right after these.
Choosing a funeral home requires enormous trust. This is Joey Young. At Young Funeral Home, we've been earning the trust of Logan Countyans since 1959. Because we are a family-owned funeral home, we understand the importance of treating you like family. We invite you to call us at your time of need or come in and discuss the benefits of pre-planning a funeral with our staff. We create personalized services that honor your loved one. Young Funeral Home with chapels in Russellville and Auburn.
This is Jerry White at Raleigh White Drugs in Russellville. This is Thanksgiving week, a time traditionally set aside to give thanks to the good Lord for all of our blessings. We should do this, and probably don't do it near as much as we should. But I've been thinking about a lot of good people that I want to thank today. I'm thinking about all the good customers who have trusted us over the years to provide their prescriptions, other medical needs, and all the other items we have at the store. I'm so aware that we owe the success of our business to you. You don't have to give us your business. You chose to. And for this, we're eternally grateful to you. And there's another group of good people I'm especially thankful to as well. These are our good employees. I'm thinking about the fine people who work for us today, trying very hard to provide the very best service to our customers. And the wonderful people who have worked for us over the years are now retired. I want you to know, both our loyal customers and loyal employees, we appreciate your support so much. We're going to continue to provide the very best products and services at Raleigh White that we possibly can every day. Once again, happy Thanksgiving, and thanks to you from Raleigh White in downtown Russellville.
Now, with another of his classes in Citizens Law School, here is Attorney Cordy Morgan.
All right. Thank you very much. And I just wanted to say happy Thanksgiving to everybody out there. We've got Thanksgiving coming up on Thursday, and I'm looking forward to it, and always enjoy his time off and being with family and all that. So anyway, I've got 3 topics today. I'm going to talk about expungements, I'm going to talk about powers of attorney, and I'm going to talk about name changes. I don't do a lot of these shows. I do the radio show called The Lawyer Show each month, and every so often I'll speak with Don, and we'll come up with a date that I can be over here just to talk about a particular topic. And that's what I'm going to talk about today. I've made quite a few notes on my computer to make sure I cover some of the things I wanted to talk about. I'm not going any great detail on anything, but I am going to give, the basics and a little bit more than the basics of these particular areas. And I think I'm going to go in reverse order from what I said. I'm going to start off with name changes, just because it's not as comprehensive of a topic as some of the other things that I will be talking about. So we are not taking any we are not taking any calls this morning. This is not a one where I'll be answering any sort of questions, which makes it easier. That makes it easy because I don't, sometimes people give me some difficult questions that I have to think about. But this is just more talking about different topics. If you have a question about something that's eating at you, and you're like, gosh, I'd like to know the answer to that, send me an email. My email address is Corey Morgan Law, that's COREYMORGANLAW at iCloud.com. iCloud.com. So if you have any questions, please keep them short, because it's like anything else. And I'll say this too, since I'm on the subject. Whenever you present something to the court, or you're presenting something to a lawyer or anybody, try to keep it short and to the point, because lawyers, and particularly judges, they're busy. They've got a lot of stuff to do, and they may have a ton of cases they're fixing to go through, and they're going to be having to look at things, and if it's long, I can guarantee you it's much less likely to be read than if it's short. If it's something that's short, it's much more likely. So whenever you present something to a court, make sure you do that as well. Don't have it anything really lengthy. Now lawyers sometimes have to have things that are more lengthy. Even when they do, they tell the court what they're wanting, and then later on they'll have like a memorandum or something that's attached that tells why, and the judge can read as little or as much as he or she wants to. But do the same thing with my email, if you will. If you have a question, just send me a short email, and I'll contact you. If I have if there's details I need, I'll contact you and talk about it. It's a lot easier doing it that way. Okay, name changes. People, of course, when they are born, they have a name which is given to them, and that name, hopefully, in a perfect world, will be where the mother and the father get together and determine, what names they want the child to have. Sometimes the names that are given to the child might be something the child likes. It may be something the child does not like. And when the child gets older, he or she may say, "Hey, I really don't like this name. I think my parents were drunk when they named me. I need to change this." And that's what we're talking about, is kind of name changes and how that works. Now, in Kentucky statutes, Chapter 401 is what deals with name changes. So you can actually go to there, and there's only a couple main statutes that deal with name changes. It's dealing with adult, dealing with a name change, and with a minor. We're going to talk about both those. The first question is, why would you want to get a name change? There's a lot of reasons aside from just not liking the name. There might be a marriage or a civil partnership. You might want to change your name because of that. You might be getting a divorce and you want to go back to your maiden name or a former name. And the Chapter 403, which is the divorce chapter, allows you to do that. They allow you to go back to your maiden name or a former name that you've previously used. You actually can't change your name to something that you haven't previously used. It's kind of strange the way the statute's written, but that's the way it is there. Otherwise, you've got to go through the formal name change proceeding. Maybe a father has a child. Usually this is something that maybe the child's born out of wedlock, and the father wants the child to have his surname. That's very common. Maybe somebody, and hopefully this is not that common, but I've heard of it, is where a person changes their name, his or her name, to disassociate themselves from a family member or a particular family surname that maybe doesn't have a very good reputation. That's something. Sometimes people will change the name so it doesn't focus on the ethnic origin. In other words, if somebody from a different country might come to the United States, they may want to change their name to something that's more commonly used, a more common name in the United States, so people can easily pronounce it and don't mess it up and that sort of thing. Another one is people like out in Hollywood or just anybody who's maybe got a certain name that he or she is wanting to use that might be more catchy or more attractive to hopefully increase the chance of that person's success. That's another reason. Okay. Now in the U.S., all the names changes are state law. So we don't have a federal name change. If you're a resident of Kentucky, you can get it changed in Kentucky. If you're a resident of Tennessee or whichever state, you can get it changed in that particular state. Now, common law, which is the main judge-made law that we use in the United States, it has essentially said you don't have to do anything formal to change your name. You can just start using a different name, and that's perfectly fine to do that. There's nothing to prohibit you from just going by a different name. Okay, some places, like say banks or other institutions, may require you to have a formal name change. What I mean by a formal name change is where there's actually, you go to court and the court orders it. Okay, to where it'll say what your former name was and what your new name is. And that's government agencies sometimes require that, such as Social Security Administration. And it also you'll need a certified copy of that. So, you go to court, the court will change your name, and you get a certified copy and take it to the Social Security Administration, and that they will change the name. That's typically how things work that way. Now, marriage is universally recognized as changing the name. So it's not, you don't have to go through a formal process when it's a marriage. You just have the marriage certificate showing that the person's married, and the female typically will take the male's name. I've seen a couple of times where the male takes the female's name, but that's very uncommon. Typically it's the female takes the male's name and surname, and you don't have to have a special court order or anything like that, because that's just recognized. That's tradition, how it's been in the United States. So you don't have to have anything special for that. Now, can you change your name to anything? The answer to that is no, you cannot. We're not like one of those countries, though, who have a list of approved names, and you have to pick a name off the list of approved names. We're a free society. At least we attempt to be as a society. And part of that is you can name your child whatever you want to name your child. You can name yourself whatever you want to name yourself. And even if it's a stupid name, even if it's a name people just shake their head when they hear it, you have the right to do it. But there are exceptions to that, just like there are exceptions to every other rule in the law. The exceptions are as follows. You can't use a name that's intending to mislead or defraud someone. You can't use a new name to evade a debt, or evade a lien, or to defame someone. You can't use that. Or to use it as a racial slur. You can't use a racial slur as a name. Also, you can't use it as a threat. There can't be the implicit in the name a threat. And you can't use it if it's obscene. Aside from those, if it doesn't, if those names, if it's an actual proper reason to do that, you can change your name, and there's not a problem. Okay, now in Kentucky, if you're an adult, the district court will enter the name change. Okay, if you have a Google or similar search engine, you can Google 401.010. Okay, now the court, you fill out the paperwork. The paperwork will request a name change, and it's actually AOC 295. All you got to do is go to the clerk's office. They'll give you the paperwork, and you can fill it out. It should be typed. Some judges will accept it if it's written, but it really should be typed in order to because it needs to be clear, and it needs when it's done what name you're wanting. If you write it, the judge may misunderstand what it is, and the order may have the wrong name, or so it's important to do that. Now the judge automatically will grant a name change for an adult unless it's an improper purpose. The judge has very limited discretion. There's, depending upon what type of case it is, some cases judges have a lot of discretion. They can do what they want to do. Some cases it's more limited. Now in a case with an adult name change, it's very limited discretion. The judge must grant the name change unless it is for a fraudulent, frivolous, or immoral purpose. In other words, the things we just talked about before. Now the venue for that is the county where the person resides. So if I'm reside in Logan County, I go to the Logan County District Clerk. If I'm Warren County, I go to the Warren County District Clerk. Pretty simple. If it's an Army post, you go to the adjacent county is the venue of where it would be located. Okay. Now, name changes for a minor. These are a little bit more complicated than name change for an adult. Name change for an adult is pretty much a slam dunk. Whatever you want, unless it's improper. Now, if it's a minor, if you have both parents or a guardian, there'll be a guardian that's taking care of a child. If both parents are deceased, can request a name change for a minor. So if you got both parents saying, hey, this is what I want the name change to be, and it'll ask you why. You have to say why you want the name change. And if it's something reasonable, it's the court's going to go ahead and grant it. The court has more discretion in dealing with a minor name change of a minor than it does for name change of an adult. Now, if only one parent agrees to the change, for instance, you have maybe Dad wants the child to take on his surname. Mama does not want the child to take on, the father's surname. Then you've got a contested issue. The court, in that case, must hold a full hearing where it hears evidence. That's what we mean when we say a hearing. It's to hear evidence. There's got to be notice to be heard, and you have the opportunity to present evidence on whatever it is you're wanting to do. And then at the end of the hearing, or shortly thereafter, the court will make a decision. The court will decide whether or not the child's name will be changed to the new name that's requested. In the event the court does change the name, then the child will start using that name as the new name, and the birth certificate will be changed and everything else. But the court can deny it because it looks at a standard. The standard is called the best interest of the child standard. The court wants to determine what is in the best interest of this child. Should we change the name, or should we leave the name as it is? And in looking at that, courts typically will say, okay, what family members have this name? Will this cause an undue hardship on the child to have to all of a sudden go by this new name? If the child's a high schooler and says, hey, I want to change my name, then the court's going to take that into consideration as well if the child wants the name changed. There's a lot of factors that go in, and that's why you have the hearing so the court can hear the evidence of what's going on. Now, one thing I will say, if you have a contested name change, it's really important to get an attorney because the attorneys know what to present to the court, knows what the information the court needs in order to make the decision. That's one of the big things on having an attorney for things. The courts have certain factors they're looking at, and the attorneys know what they're looking at, so they can present it for the judge to make that decision. And a lot of times, if you speak with an attorney, the attorney will be like, well, you don't have a chance in changing this name or whatever the other legal matter is. They'll tell you ahead of time. They'll give you advice on it. Okay? Now, whenever there is a contested name change, like of a minor, the court has tremendous discretion. The discretion's out here. It's not here like where you have in an adult name change. It's a lot of discretion involved. So that means that as long as the court bases the decision on information that it heard from the hearing, on evidence that it heard from the hearing, then it's probably going to be okay. You can appeal it, and the appeals court's not going to change it because the appeals court's going to look at it and say, oh, well, they have a lot of discretion in determining that. So anyway, one thing that I want to mention as well, people, I think, believe that if it's a father and the father is asking for a name change of a minor to his last name, to his surname, that it's going to be an automatic situation. And in fact, it is not automatic. It's not automatic at all. The court still has to determine the best interest of the child. Now, if the child has most of his or her family members with the last name that the child has, the court's unlikely to want to just change the last name, just to suit the father when the child's been going by it and everybody knows the child by it, and it's, there's a lot of reasons why that might not be a good idea for the father. I understand tradition says yes, you need to change the last name to the father's surname. So a lot of times you have a case where maybe a father, it's an out of wedlock situation. The father does get paternity established. But even though the father gets paternity established, it's not a foregone conclusion that the last name is going to be changed. Okay? Now, how do you do that procedurally? How do you do a name change? Well, there's a form that is an AOC 295. That's AOC 295. That's the form, and it's at the district clerk's office. As I said, if you're whatever county you reside in, go to that district clerk's office and request that. Now, if it's a minor, you need to go to the county where the minor resides, and you can take that and fill it out and get it back. The form, as I said, should be typed. Please double check it, triple check it, make sure it's all the spelling's correctly, because it's vital that the spelling is correctly done. Excuse me, correctly done if it's dealing with a name change, because you want to make sure the name change is correct. There will be a filing fee. I'm not sure the amount the filing fee. I know it's less than $100, but that will be a filing fee. Now, if it's a contested situation with just one parent filing, you'll have to serve the other parent, and that's, once again, you need to get an attorney to do that. Now, whenever you go to court, the court grants the name change, you need to make sure that you notify all government agencies relating to that name change. Even if it's for a minor, you need to make sure you notify the government. Now, this includes things like birth certificate. You need to get the birth certificate changed to the new name. The Social Security Administration, they will need to know what the new name is. The driver's license or state ID card that you have, that will need to be changed. Voter registration. Now, if you go in with a different name to try to vote, Kentucky, they check the IDs, you won't be able to vote. So you need to make sure that gets changed. Any passport needs to be changed. Post office boxes will need to be changed, so they need to make sure that otherwise, if you got a different surname or a different name altogether, they'll say, oh, this person doesn't have this box, and send it away. So you won't need to make sure that's changed. Or anything dealing with financial information. If you've got a loan at a bank, mortgage, security interest in an automobile or other personal property, credit cards, anything that would deal with something, you need to make sure that they understand that you've got a new name. And that's why it's important, too, to get a whole bunch of copies of that name change order. And whenever you're telling somebody, send them a copy of it, of the order signed by the judge, and that way they know you're not lying to them. They know that you're actually, in fact, have had the name change. So, anyway, now that is a good rundown of name changes. And I would advise, even though, as I said, the law allows you to just start using a new name without having to actually formally change it, I always advise to formally change it. That way there's no question. That way you don't run into particularly problems with governmental agencies. I believe it's time for a break, and then when we come back, I'll start talking about powers of attorney. Thank you.
Knight Electric has proudly served the people of Logan County for over 40 years. Whether the need was residential, commercial, or industrial, electrical, heating and cooling, or large equipment, Knight Electric has been trusted to provide highly trained technicians who are skilled and take pride in their work. Their long track record of success is based on the trust their customers and clients have shown. At Knight Electric, they're thankful for each and every customer that's called on them. They're thankful for the opportunities to bid jobs and earn your business. They're thankful for their dedicated employees that represent the company. If you need a great local electrical contractor, contact Knight Electric. Find out about the variety of services they provide, from HVAC maintenance and installation to 24/7 service, electrical wiring, inspections, dozing, and drilling. Knight Electric, 286 Farmers Drive, Russellville, phone 270-726-3818. License number MO4318.
Shop close to home this week as you celebrate Thanksgiving with your Russellville Piggly Wiggly store. Best Choice Grade A turkey, 99 cents a pound. 10-pound and over with pop-up timer. Shank portion smoked ham, $1.19 a pound. Sweet potatoes, 29 cents a pound. Crisp celery, 69 cents each. And Best Choice vegetables, 2 cans for $1. Duncan Hines cake mix, 99 cents a box. Best Choice granulated sugar, the 4-pound bag is 2 for $3. Crisco vegetable oil or canola oil, the 48-ounce bottle is 2 for $5. Pick up Martha White, Pillsbury, or White Lily flour or cornmeal mix. The 5-pound bag is $1.99. Kraft Cool Whip, 99 cents. Purity ice cream, the 48-ounce carton is 2 for $6. And Pick Sweet vegetables, 99 cents a bag. Save more when you shop for Thanksgiving this week at your friendly and convenient Piggly Wiggly in the Bethel Shopping Center, Russellville.
This is Jerry White at Raleigh White Drugs in Rossville. This is Thanksgiving week, a time traditionally set aside to give thanks to the good Lord for all of our blessings. We should do this, and probably don't do it near as much as we should. But I've been thinking about a lot of good people that I want to thank today. I'm thinking about all the good customers who have trusted us over the years to provide their prescriptions, other medical needs, and all the other items we have at the store. I'm so aware that we owe the success of our business to you. You don't have to give us your business. You chose to. And for this, we're eternally grateful to you. And there's another group of good people I'm especially thankful to as well. These are our good employees. And think about the fine people who work for us today, trying very hard to provide the very best service to our customers. And the wonderful people who have worked for us over the years are now retired. I want you to know, both our loyal customers and loyal employees, we appreciate your support so much. And we're going to continue to provide the very best products and services at Raleigh White that we possibly can every day. Once again, happy Thanksgiving, and thanks to you from Raleigh White in downtown Russellville.
All right, we're back here. I'm going to talk now about powers of attorney. This is a little bit more comprehensive topic than the name change, but I'm going to try to just talk about the main points about it. And now, what I guess the first question would become, what is a power of attorney? Now, a power of attorney is a document where one person who is called the principal authorizes another who is called the agent, or sometimes called the attorney-in-fact, to act on his or her behalf. People do this for various reasons. This could be that maybe somebody's in jail and needs somebody to deal with third parties for the person who is in jail. Maybe somebody is in the military. I remember when I was went to Desert Shield and Desert Storm, I had to give power. I didn't have to, but it was prudent to give power of attorney to my parent to allow the parent to go and do specific things for me, financial things, while I'm overseas. Of course, I'm unable to do that. I'm still receiving paychecks and things of that nature that's going into direct deposit into my account, and somebody's got to take care of that, make sure my bills are paid, make sure my car payment's paid, things like that. Excuse me. But that's what a power of attorney does. Now, power of attorney is kind of a narrow topic under a broader topic called agency law. Now, agency law is a very very complex topic that deals with when you have a person or organization who acts on behalf of someone else. These include things like partnerships. The partnership. Say you've got a partner, and the question is, well, did what the partner did it bind the partnership, or did it not bind the partnership? Same thing with corporation. All a corporation is a piece of paper. So you have representatives of that corporation, and when can they bind the corporation on particular, whether it's a contract or things like that. And that's agency law. Like I said, it's a very, very broad topic. We're talking about a more narrow topic. That's just giving the power to somebody to act on your behalf. I've heard, ever since I've been practicing law, people tell me, it's like, oh, I gave so-and-so my power of attorney, meaning that person's the principal and the other person is the attorney-in-fact or the agent. And my so-and-so, whoever it was, the attorney-in-fact, is going to put me in a nursing home or is going to do this or that. Now, that is not possible. A power of attorney just merely allows the other party to act on your behalf. And I'm going to talk about some of the duties and things like that in just a minute. Now, like I said, it's part of agency law. Because it's agency law, there is a fiduciary relationship between the principal and the person who is the agent or the attorney-in-fact. And I'm going to talk about what that means in a few minutes. Now, it's between two parties, at least two parties. Like you're going to have the principal, and he lets one person act on his behalf, or two people act on his behalf jointly, or they could do it by themselves. However it's written is how that's done. Now, it's formed by mutual consent. You can't force anybody into a power of attorney. Not like a guardianship or something of that nature, where you can actually you force somebody into being their guardian if they're unable to take care of their affairs. Now, when the agent, I should say, the agent will agree to act on behalf of the principal, and the agent is subject to the principal's control. So if I give somebody power of attorney, they have to agree to work on my behalf. And it can be for money. Money can be involved, or it can be a gratuitous agency where they're doing it without any payment. Either way, they're subject to my control. They can't do anything until that's beyond what I tell them they can do. Now, I talked about fiduciary duties, and I'm sorry I keep fighting back the cough here because I've been a little bit under the weather. Fiduciary duties, there's different. That's when you act in a special relationship with someone. So if you've got an attorney-in-fact and a principal, there are the following duties. There's duty of candor. That means that the attorney-in-fact, the person who has the power of attorney, has to be candid and give information to the person who's the principal. There's a duty of loyalty, and the agent or the attorney-in-fact can't have any secret profits or self-deal. They can't make money on my power of attorney that I gave them. They have the duty to account for profits. Maybe I have them buy or sell something. They have to account for whatever it is that has been done. They have the duty of obedience. They have to follow reasonable instructions. And they also, there's no competition during the arrangement. So if I give somebody the power of attorney they're the attorney-in-fact, the attorney-in-fact cannot compete against me because I'm the principal. But after the relationship is over, they can compete as long as they don't use any particular special information that they receive from the using the power of attorney. Okay. Now, there are different types of powers of attorney. There is something called a general or full power of attorney, and that's power to cover all business and financial matters of the principal. So I could give somebody the ability to do everything that I could do myself as if I were there. Or there could be a special or limited power of attorney. A special or limited power of attorney is power to perform a specific specified transaction in a specified manner. Example, I may want somebody to sell my house. Maybe I'm going to be out of the country and I say, okay, brother, I want you to sell my house for me and give my brother a power of attorney to do just that one particular thing. That's a special power of attorney. And then once the house is sold, it is complete. And I can say I can have broad powers, or I can have narrow powers. I can say to sell my house located at such and such location for such and such amount to this particular person. I can do that, or I can say just sell my house at whatever price he deems appropriate, or to whomever he deems appropriate. It can be as broad or as narrow as it needs to be. Now, there's also something called a springing power of attorney, or sometimes it's called conditional power of attorney. What that means is the power of attorney I give, the powers to the attorney-in-fact, are conditioned upon some event occurring. Usually, that event is because I, the principal, become disabled or mentally incompetent. And if I have that, there's a statute in Kentucky that's KRS 386.093 sub paragraph 5 says what disability means. It's two physicians essentially that determine whether somebody is disabled. So that doesn't go into effect actually until that determination has been made. Another type of power of attorney is a medical power of attorney, and that's where you allow somebody to take control over your health care decisions in the event the principal becomes incapacitated. So that helps with the health care type decisions. Now, a power of attorney ends by operation of law in the event a principal becomes incapacitated or dies. What I mean by operation of law is you don't have to do anything special. It just happens automatically. If the principal becomes incapacitated let me use an example. Say I give my brother a power of attorney, so he's the attorney in fact, and I'm the principal. If I become incapacitated, that power of attorney is no longer any good for my brother. Now, if I die, that power of attorney is no longer any good for my brother. There is something that is called a durable power of attorney, and you may see that when you see a power of attorney form. What durable means, that term means that the power of attorney is not affected by subsequent disability or incapacity of the principal. So if I had a durable power of attorney that I gave my brother, I would not, and I became incapacitated, my brother could still use the power of attorney. It wouldn't have any effect at all. Now, the language, there's a statute that we have, the same statute I mentioned a moment ago. It's KRS 386.093, and it states that this is the language that's used. This power of attorney shall not be affected by subsequent disability or incapacity of the principal or lapse of time. So if that language, it doesn't have to be exactly that language, but if it's something that's substantially similar to that type of language, then it would make the power of attorney to where it remains in effect, even if I, as the principal, became incapacitated or disabled to where I didn't know what was going on. Okay, now that's by statute in Kentucky that happens. Now, it also states in that statute, which is interesting, is that if although a power of attorney ends immediately upon death, if the attorney in fact, meaning like my brother in my instance, did not realize that I had died, and he's still making transactions on my behalf in good faith, that's okay. There's nothing wrong with that. But as soon as the attorney in fact has knowledge of my death, then the power of attorney stops at that point. Now, there's an old saying in contract law that whoever is making an offer for something is the master of the author, the master of the offer. Can't talk today. And that means that the whoever's making an offer gets to determine all the terms of that offer. And it works the same way when you have a power of attorney. I like to say it's the master of the authorization. So if I'm the principal, I'm the master of the authorization. I say how much authorization I'm giving the person who's the attorney. In fact, I can give them a broad scope authorization or narrow. And the power of attorney, the attorney in fact, must go by whatever the authorization is. If it's the narrow, he or she cannot go beyond that. And if he or she does go beyond that, then there's personal liability for the attorney in fact. That's why it's important to make sure you read the document and make sure it's the way it needs to be, and make sure both parties understand what the duties are. Makes it easier for a general power of attorney, because general powers of attorney, you just pretty much give any authority to do anything that the principal could do. Now, you can authorize somebody to do pretty much anything, but if the principal is authorizing the attorney in fact to make a gift, then that has to be unambiguously stated on the face of the instrument. That's how the statute reads, unambiguously stated on the face of the instrument. So you got to specifically say you have the power, this attorney in fact has the power to give a gift, because most people don't have attorneys in fact to give gifts. They usually to do business type transactions. That's why. Now, what about formal requirements of a power of attorney? Now, powers of attorney do not need special language or be in a particular format. They have to clearly set out the powers which are authorized, and whether or not it's durable, meaning whether it's going to continue on during the incapacity or disability of the principal. In order to be recordable, a power of attorney has to be acknowledged or approved in the same manner as a conveyance, like a deed has to be in the same format. Now, it also must have the name, address, and signature of the preparer unless it is self-prepared. That's in order to be recordable. So generally you'll see that it is notarized by a notary public. That's usually what is done whenever there is a power of attorney. And I would advise always have it notarized by a notary public. And part of that is that you don't know where that power of attorney is going to be used. If it's going to be used in another state, they may require that. Kentucky, believe it or not, does not require a notary signature for a power of attorney. But there's a few caveats to that. Number one, most people are not going to accept it unless it's been notarized, because how do you know that was actually the person that has done that? Number two, I have never seen one that is not notarized, because attorneys always know, it's important to have it notarized. Number three, it's important to record it where the deeds are located. Attorneys, as a matter of course, will generally say, you record this power of attorney where the deeds are. So it gives everybody notice of what the authority is and the fact that that person can act on his or her behalf. And also it's important too, because then you can show when it's been revoked. It's really clear when it's been granted, and it's really clear when it's been revoked. The law actually says you do not have to record a power of attorney unless you're selling real property or dealing with personal property in a way that the law says you have to have it recorded. But if you don't get anything else out of this power of attorney talk right now, know that you always need to file it, because it protects everybody by having it filed, especially the principal it protects by having it filed as well. Now, revoking a power of attorney, a special power of attorney that we talked about is revoked whenever the transaction is complete. Say, selling a house, once the house is sold, the transaction is complete, it's revoked. There's a naked power of attorney. What a naked power of attorney means, without any money changing hands between the principal and the attorney, in fact, can be revoked at any time, even if I as principal say it's irrevocable. So it can be revoked at any time. Now, a power of attorney coupled with an interest is irrevocable. That's if we have an agreement where there's money exchanged, and I'm supposed to they're supposed to be able to use a power of attorney. That'll continue. It even survives the death of the principal. We ready for a break? Okay, we're gonna have a break. Thank you.
At Freeland Chrysler Dodge Jeep Ram, their deals are sweeter than Mama's pumpkin pie. Shop the other guys, then check them out at Freeland. They'll meet or beat your best deal. Special incentives make it easier than ever before to put a gift in your driveway this year. Right now, all 2016 models are on sale at Freeland. It's simple. Take the invoice price, subtract any eligible rebates, and that's your cost. We're talking thousands off brand new Chryslers, Dodges, and Jeeps. The Ram Black Friday sales event offers 0% for 72 months on select quad cab 4x4s. Freeland has a tremendous selection of used vehicles on the lot, and the finance department will find the absolute best deal for you. Stop by and see them today at Freeland Chrysler Dodge Jeep Ram, 1451 Bowling Green Road, Russellville, Kentucky. Call 270-725-4100 or shop online 24/7 at freelandcdjr.com.
This is Joey Young of Young Funeral Homes Incorporated. When you lose a loved one, a number of details must be worked out in a relatively short amount of time. The pressure of these decisions is only made worse by the grief the family is feeling. Since 1959, our community has trusted Young Funeral Home to help them through this difficult time. We create personalized services that honor your loved one. As a family-owned funeral home, we understand the value of family and know that's how our friends and neighbors deserve to be treated. Young Funeral Home with chapels in Russellville and Auburn.
All right, getting back here, we're finishing up on the power of attorney. Revoking a power of attorney, you can, or I should say you should, revoke it in writing. It's important to do that. I guess technically you could rip up the instrument or that's a way that you can revoke it. However, if it is in fact recorded as it should be, that's good, prudent practice to record it. Then there needs to be a revocation of power of attorney, which will be filed, showing that there'll be either a separate document in the court records, or they'll make a notation on the original power of attorney that it is in fact revoked. And whenever you revoke a power of attorney, one thing that's important as well is to make sure to notify everyone who has previously relied upon the power of attorney. Maybe it's a particular bank that relies on the power of attorney. That particular bank needs to be notified, hey, I have revoked this power of attorney, and so, my attorney in fact does not have any more ability to enter into transactions on my behalf. It's important to do that, because if the bank doesn't realize it and still enters into contracts or with the attorney in fact, possibly you could be bound. You may not be, but possibly you could. The best thing to do is just make sure you notify everybody about the revocation. That way there's no issues of it, because once an organization or a business or an individual is notified that the power of attorney is revoked, from that point on, if they enter into a contract with the attorney in fact, it's strictly the attorney in fact. They cannot bind me with any transaction on that. Okay, now that's attorney powers of attorney issues. Now we're going to jump over to expungements, and let me pull this up here. Now, there's been quite a few changes in the law regarding expungements. Expungements used to be very, very difficult to get in Kentucky. I don't know why they're so difficult to get, but it used to be, if there was an expungement, then you would have 5 years look back. That you'll go back 5 years, and then to look at the the crime or traffic offense or whatever it is, and then you have to go back another 5 years. Well, they've changed a lot of that. And if it used to be that if you had a felony, you could never get that expunged, and that's the way it's always been. Keep in mind, if someone is convicted of a felony, which is a crime where the maximum punishment is a year or more, that means that you lose your civil rights. You lose your right to vote, lose your right to possess a firearm, lose your right to run for public office, you lose your right to a lot of jobs. There's a lot of things that you lose. And formerly, before this law was changed, the only way to get a felony off your record was to be pardoned by the governor. And even then, it's not off your record. You may be pardoned, but there's still record of the felony that you're just pardoned and given back your civil rights. So that's the way it was, and we still have pardons. But just like the President of the United States has the power to pardon, for federal crimes. Now, I've heard people say, it's like, whether the president pardons somebody for a Kentucky crime. Well, that's not. The president is federal. The president can pardon for federal crimes. Kentucky is a state, its own sovereign. The governor can pardon for state crimes in Kentucky. The governor can't pardon for other states, only for the state of Kentucky. So that was what was done previously. Now we have the ability to expunge Class D felony convictions. Now, what does that mean? A Class D felony conviction is a lower level felonies. That's the lowest level felony, I should say. It's 1 to 5 years. These are a lot of your possession type crimes and things of that nature. Now, you can also expunge, meaning wipe away your record to where there's no record of it. Whether you're something that you're acquitted on, meaning you're found not guilty, or charges against you have been dismissed. Those are the abilities. Those are what you can now expunge. You can also expunge misdemeanor convictions. Now, people think, well, gosh, I had my case was dismissed. It shouldn't be on my record. Actually, if you're charged with something, then when that charge is dismissed, it remains on your record. It's not something that goes away. You have to ask for it to go away. And that's why you have to actually go through the process of getting an expungement. Now, for misdemeanors, here's how this works. If there are any criminal charges pending against you, you are ineligible for an expungement. That's the same thing as if it's a felony. If you have been convicted of a misdemeanor or felony in the past 5 years, you are ineligible for an expungement. You will be eligible in the future, but you're just not eligible right now. Now, has 5 years passed the completion of your sentence? And if the answer to that's no, then you're not eligible yet. In other words, if you have a misdemeanor that has a 2-year conditional discharge, which is like a probation, it actually takes 7 years because it's 5 years from the 2-year period. So that before you become eligible. Now, if it's an offense against a child or a sexual offense, the nature of it's sexual, that will never be able to be expunged. Because they want to make sure that people have records of that to protect, I guess, the children, and also, something that is high in recidivism. Now, if it's an enhanced offense, now the DUI statute now goes back 10 years. So, because it goes back 10 years, you have to actually wait that full amount of time before you can ask for an expungement, which you used to not have to do. Now, Class D felonies, it has to be on one of the eligible felonies list. And what I'm going to do is I'm going to go through sometime today and put on my my website. It's CoreyMorganAttorney.com. CoreyMorganAttorney.com. That's my Facebook website. I'm going to put on there all of the eligible felonies that you can expunge. That way you know what that is. Once again, you have to wait for felony expungements. You have to wait 5 years. You can't have anything pending. The whole process you need to do is, and keep in mind too, I want to mention the previous expungement. I should say that the charges you can expunge, if it's a violent, they're not going to let it either. I talked about child offenses and sexual offenses. Violent offenses also they will not allow as well. Now, how do I expunge? First of all, you have to get a certificate of eligibility. Certificate of eligibility that costs $40, and the state will send that. Will send your certificate of eligibility to you or to your attorney, which tells you whether or not the state believes that a particular crime can be expunged. Doesn't mean they're right. It's up to the judge ultimately whether to expunge something. But if in fact it says that it's eligible, then it'll be eligible. The judge will allow you to expunge it. Now, once you receive that, then you have to file within 30 days, and we're just about done on time here. You have to file within 30 days the information and the request with the court to have it expunged. And there's quite a there's money that's involved as well if it's something that's a conviction. Now, acquittal dismissal, there's no charge, but if it's normally $100 per case if it's a misdemeanor, or $500 a case if it's a felony, and you get $450 back if they don't allow the expungement of a felony case. Do we have more time? Okay, got about 1 minute or so. So I want to mention whenever you do that, there will be a hearing on that. Now, acquittal and dismissal, there's not a requirement for a hearing. Judges may have a hearing on that if they want to do that, because it's not automatically dismissed, but it is something that you're asking the court to dismiss. For instance, you may have something that is a dismissal, and the reason why you have a dismissal is you agreed to have that dismissed in order to plead guilty to something else, and that might not be automatically dismissed. I should say automatically expunged just because in fact it's a dismissal. The court will look at it. The county attorney or the Commonwealth attorney will also have the ability to oppose it if they believe that in fact it's not something that needs to be expunged. Maybe, because sometimes it's important for the public to know things and hear things.
And Attorney Corey Morgan's been here this morning teaching his Citizens Law School class. Stay tuned for ABC News coming up here at the top of the hour on the 24-hour AM 610 WRUS Russellville, Kentucky, the Trinity Episcopal Church.